Welcome to Expert Views on ADR Ever, a podcast about simplifying alternative dispute resolution in a bid to attract more and more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is Dr. ChinweEgbunike, and I'm pleased to welcome Ukpeme Okon to the show. She is the founder, trustee, and the president of the Guild of Adjudicators in Nigeria again, as well as the author of The Value String, a book on transitional life, compelling fulfillment, and profound peace. She's also a lawyer, arbitrator, adjudicator, mediator, ambassador for peace, and trainer with over 14 years of background in law practice, training, peace building, and leadership. Her core competencies include mediation, negotiation, writing and research, opinion writing, ADR, and public speaking. Welcome to the show, Ma.
Greetings, Chinwe.
Hi.
Greetings, everyone listening. Thank you for the opportunity.
Well, thank you for coming. I'm so grateful. So without further ado, let me go straight to the questions. So the first question is, what is an adjudication process?
Thank you for that question. The term adjudication may be confusing because adjudication generally refers to the process of deciding a case or resolving a dispute. Nonetheless, in reference to alternative dispute resolution, an adjudication process involves resolution of a dispute between parties by a neutral third party known as an adjudicator, who is an expert in the subject matter of the dispute. The decision of the adjudicator is binding until or unless it is revised.
All right, thank you so much. So is this classified on the ADR?
Yes, adjudication is classified under alternative dispute resolution, also known as ADR. It's one of the mechanisms because the process of adjudication involves settlement of or determination of disputes outside of the court process. And that's what makes it an alternative dispute resolution mechanism. So yes, it is a method of resolving disputes outside of the court system.
Okay,
ADR is an ADR method.
Because sometimes it's confusing as well. To some people have come up, what's this on the ADR? And I said, oh yeah, I'll get an expert to answer that. So you've answered it, so it's on that ADR processes. Okay, so thank you for that. So what are the types of adjudication and where can it be classified? Okay, we've answered the question. So the types of adjudication, is there any type of adjudication?
Indeed, to the extent that I know, there are two types of adjudication processes, or there are two types of classifications for adjudication, to the extent that I know. The first one is the statutory adjudication, which is a process where adjudication is has the backing of a law or legislation of any jurisdiction or any country or in any community. So it's backed by law. I'll give an example of statutory adjudication, which is provided by legislation. So an example is in the United Kingdom, where we have the Housing Grants, Construction and Regeneration Act of 1996. So that law provides for dispute resolution using adjudication. And because it's there are many countries that don't have legislations or laws that provide for adjudication. For instance, when we talk about arbitration, there are many countries that have their adjudication acts. that provides for resort to arbitration. But adjudication is a novel, it's not a very common ADR process. So there are many societies or countries that don't have it as a statute or as a law. So, but for the countries that have it, like the example I mentioned in the United Kingdom that has provision for statutory adjudication, adjudication as a method can be commenced or can be resorted to through statutory provision. So the first one, I have two types to the extent I know. So the first one is statutory adjudication. And the second one is contractual adjudication. And the contractual adjudication is the type of adjudication which refers to a situation where parties agree to resolve disputes between them by adjudication. And this happens when this occurs when or is occasioned by inserting the appropriate adjudication clauses or the appropriate adjudication clause or the appropriate adjudication term in the contract between them. So even if it's not a contractual, even if it's not a statutory adjudication and parties decide that we want to resolve, if disputes arise between us, we would like to resolve our disputes by adjudication, by adopting the adjudication method, then that can be a type of adjudication. So there are two, to the extent I know, for now. Maybe after this interview, I might remember others, but to keep it simple, statutory adjudication and contractual adjudication.
Okay, thank you so much. Yeah, well, the show is about simplifying ADR, so it's good that you're keeping it simple.
Thank you.
All right, so the third question is what is the purpose of adjudication and its benefits?
That's a good question. The purpose of adjudication is to ensure quicker, simpler, less expensive, impartial dispute resolution. That is the main purpose of adjudication. So to ensure that disputes are resolved quicker. ADR generally, ADR processes generally have that quicker resolution of dispute, but adjudication has a special quick method of resolution. So to ensure that it is a quicker process, it is simpler, it is less expensive, and it is impartial. So the resolution process is fair to the parties concerned. That's the main purpose of adjudication.
And this is just the same benefits, purpose of ADR as well. You know, what you've just outlined. Okay. So the benefits, they're similar or they're the same. Yeah.
So the benefits, the question about the benefits of adjudication is that because regardless of the nomenclature of the ADR systems, they have common features among them. So you keep having, just as I mentioned, the purpose of adjudication, but the benefits of adjudication compared to other alternative dispute resolution methods, and due to its time-sensitive nature, that's the main benefit now. Is, in my opinion, the adjudication is the quick alternative dispute resolution method compared with, it's quicker compared with other ADR systems. So that's the main benefit, because the general benefits of ADR also apply to adjudication, but now comparing it to other ADR methods, it's quicker or quickest, because it's not just adjudication, we have several. So it's quickest method of resolving the disputes among or between parties.
So in terms of cost, I've heard that adjudication could be expensive than mediation.
I have one of the advantages of alternative dispute resolution is, or one of the aims or one of the objectives is to have a less expensive method of dispute resolution. But it's really, really relative, really relative, because even if it's less expensive in terms of the time that is in the time that is applied in utilizing that method, sometimes it's even more expensive than than even going to the courts, even resorting to court. I've had experiences where I'm an arbitrator in a particular matter that is still ongoing for years. And it's for years. And you can imagine the amount of money that is spent on that case up till this day. So sometimes the conduct of parties or the conduct of the tribunal really matters in some of these ADR methods, because even if the intention is to make those processes less expensive, but sometimes they're actually expensive. So it all depends. It depends on the conduct of the parties. The intention is to make it less expensive, but it could be expensive if the tribunal or the parties don't stick to the procedure, or don't stick to the terms, or don't stick to the process. And so by unduly extending it, it can make it more expensive. Than.
Oh, thank you for clarifying that. So what is the difference between litigation and adjudication?
The difference. There is a difference between litigation and adjudication. Litigation is a public legal process in which disputes between parties are settled through the court system. So in relation to adjudication, litigation is public. Adjudication is a private process. So litigation is a public process, adjudication is a private process. And then there are another difference to note. I will just concentrate on two main differences. And then the other difference is that in litigation, the courts, the judges are assigned by the relevant court system. But in adjudication, parties appoint the adjudicator. So parties have the ability, they have the freedom, they have the
party autonomy.
Autonomy, yes, they have that autonomy to appoint whoever they wish to serve as an adjudicator in the dispute between them. So those are the two main differences. One is the issue of privacy. One is public, litigation is public, and adjudication is private. Under litigation, the judges are appointed by the relevant court system, and adjudication has the parties appointing the adjudicator.
All right, thank you so much for that. And so what are the similarities and differences between adjudication and arbitration?
Adjudication and arbitration, there are two ADR systems, adjudication alternative dispute resolution systems, and they share similarities, and they also share differences. So the similar features I would highlight are that they both have this consensual nature and party autonomy. So parties have this, they reach a consensus as regards the process, unlike maybe litigation where it's the court, is the judge. So the process is driven by the judge mainly. So the similar features are, one, the consensual nature, and party autonomy. Another similarity is that the processes are geared towards quicker resolution of disputes. The third similarity I would mention is that they are private methods of dispute resolution.
Okay.
Another similarity is that both procedures are flexible. There's that flexibility for the parties. The process is just flexible, and that's an advantage too as well. Another similar feature between them, the processes, is that both procedures have statutory provisions, as I mentioned earlier. So adjudication has statutory provision, and also adjudication has statutory provision. And when I was mentioning the appointment of the parties can appoint the adjudicator, in this, I think that if parties fail to appoint an adjudicator, maybe if one party is recalcitrant or is not appointing an adjudicator for the process that parties have agreed to submit to, the other party can also resort to the court. So there is also that interconnectedness between the court system and these ADR mechanisms. So these are the similarities. And then also that the awards are just like what you are similar to judgments. So an arbitral award or an award in adjudication in both procedures. So the awards in both procedures are enforceable and are final until or unless they are set aside. These are some of the similarities between adjudication and arbitration.
All right, thank you so much. Who can be an adjudicator?
Who can be an adjudicator?
Yeah.
Anyone can be an adjudicator. But expertise in the adjudication process is necessary because the qualification of an adjudicator may be required by parties before an adjudicator can be appointed. So also a subject matter expert, a subject matter expert adjudicator is able to efficiently and effectively resolve an adjudication case. So even though anybody, when I say anybody, I'm not implying that a child can be an adjudicator, but but
I understand.
Someone you have a basic knowledge of, it's good to have at least that basic knowledge of ADR, alternative adjudication process, and also adjudication. And so whatever profession that one professes or whatever profession one has or practices, even if you're a teacher, you're a lawyer, you're a medical doctor, you're whatever it is, you can be an adjudicator. The passion is necessary to have the zeal to serve as an adjudicator, and also to get the knowledge about it, because you also have to know what it is that you're adjudicating about. And then you also have to get that even basic knowledge and continuous learning, because even we in the practice as resolutionists, we need to continuously learn. We need to also keep abreast, keep abreast with the practice. So anyone that is desirous of it can, is not exclusive to any profession. So anyone, any adult that is passionate about the process and likes to resolve disputes fairly can be an adjudicator.
Okay, so I think you've touched on the final question, which is, what is your advice for people who want to pursue a career in ADR?
Okay, can I proceed on that?
Yes, carry on, but say something relevant.
So I will, yes. So for people or for persons or anyone that wants to start a career in adjudication, my advice would be to acquire knowledge on adjudication, to acquire skills, not just the knowledge. You also acquire the skills on how to apply the knowledge. So acquire the knowledge, acquire the skills and experience. See, knowledge, skills, and experience. In the adjudication practice, as well as joining an adjudication organization. For instance, Guild of Adjudicators in Nigeria.
Yeah,
which is
I'm a member.
Yeah, proud, happy member. Yes, thank you so much. You're a valuable member of that organization. So joining an organization, and Guild of Adjudicators in Nigeria is a prime organization for adjudication in Nigeria. So I would also advise people who would like to start a career or learn about adjudication to also join relevant organizations such as Guild of Adjudicators in Nigeria, also known as GAIN, where they can also gain knowledge about adjudication. So Guild of Adjudicators in Nigeria is the first of its kind in Nigeria. And it's also a multidisciplinary organization, which was founded by Ukpeme Okon. Yes, and it was incorporated on November 22nd, 2013. So anyone that intends to start a career, these are some of the paths that anybody can to follow. So acquire knowledge, acquire the skills, acquire the experience, join an adjudication organization, and among others. Among other things that they can do.
Okay, thank you so much for giving us a masterclass on adjudication. And like I said, you've succeeded in simplifying it. And some of the questions that some of the listeners asked me was if adjudication was on the ADR. So I'm really happy that you've done justice to that. So I believe that this is also an eye-opener for people who are yet to know or realize that these alternatives are available. Of course, it's much more, I wouldn't say cheaper, it has more advantages than litigation. Though, like we always say on this show, that it's not all cases that should go to ADR. Some should, some cases are, it should go to litigation. But most of those cases, if people and the society are knowledgeable, or if they have this knowledge about ADR. Some people don't really know about ADR. They can, decide to opt for these mechanisms instead of relying or using litigation. So thank you so much for, coming on the show and simplifying adjudication for us. All right.
I'm delighted. Thank you. Thank you.
All right. Thank you so much. Bye-bye. Stop recording.